Welcome and thank you for joining us. Today we're tackling a topic that's increasingly urgent for every law firm in the district: how to use generative AI without conflicting with your professional responsibility. If you've seen any updates, you know that lawyers have been sanctioned, firms have faced scrutiny, and clients have been put at risk by AI mistakes that were entirely preventable. ABA Formal Opinion 512, issued in July of 2024, gives us the framework. DC Ethics Opinion 388, issued earlier in that same year, gives DC the local guardrails. In this webinar, we'll walk through what those obligations mean for your day-to-day practice, what good governance looks like, and what firms need to focus on moving forward. My name is Scott Midgley, and I'm the co-founder and chief information officer at Wellforce. Wellforce is a managed services provider based in the DC and Research Triangle markets. We work primarily with sectors where compliance matters, like law firms and nonprofits. Across those sectors, the common thread is the same: professional or regulatory obligations that require more than just good IT. They require good IT that's documented, defensible, and audit ready. For the past 15 years, I've been helping firms work through their technology challenges and meet their governance and compliance obligations. Now, with the ubiquity of available AI tools, it's vital that law firms understand which tools are safe to adopt, how to evaluate them, how to build the governance framework around them, and how to do all of that in a way that helps meet your professional responsibilities. And that's why I'm here, not as an attorney or as an ethics counsel, but as someone who sits at the operational layer, working with firms that are figuring this out in real time. So let's get into it. There's two key moments that have framed where we are now. First, in April 2024, the DC Bar issued Ethics Opinion 388. This uses the Mata vs. Avianca case as its springboard. That's the New York case where our lawyers cited fictional ChatGPT generated cases in a federal brief. This also lays out which DC rules of professional conduct attorneys need to think about when they use generative AI. In July 2024, the ABA Standing Committee on Ethics and Professional Responsibility issued Formal Opinion 512. This is a national framework. It's not binding in DC in the way that Opinion 388 is, but it's the most comprehensive treatment of attorney AI obligations to date, and DC courts and disciplinary bodies have been looking at it. Also in 2024, DC formally joined 40 other jurisdictions in explicitly recognizing technology competence as a part of your duty of competence under the rules of professional conduct. That leads to the question: if you're using AI without governance, or refusing to engage with it at all when it would clearly serve your client, you need to keep listening. Here's our roadmap for the next several minutes. We'll start by walking through the 5 core ethical obligations Opinion 512 addresses. We'll dive into each one in depth because the framework is only useful if you know what it looks like in practice. We'll also have 2 live demos that are built in. The first comes after we cover confidentiality, when we'll walk through how to evaluate a real AI tool's terms and privacy policy. The second comes after the supervision section, when we'll look at what a firm AI policy looks like in practice. We'll also be threading DC Opinion 388 throughout, because in the district, that's the operative local guidance. So let's take a look at the 5 core obligations. Opinion 512 didn't invent new rules. It applies your existing professional responsibility duties to a new tool, but here's the framework. 5 core obligations: competence under Rule 1.1, confidentiality under Rule 1.6, client communication under Rule 1.4, supervision under Rules 5.1 and 5.3, and reasonable fees under Rule 1.5. When AI-generated content makes its way into a court filing, you also have Rule 3.3 candor obligations and Rule 3.1 meritorious claims obligations to think about. That's where the hallucination cases come in, Mata vs. Avianca, and the parade of similar sanctions cases since. We're going to walk through each of these in turn. The takeaway that I'd like you to leave with is that none of these are exotic. You already know how to think about competence, confidentiality, and supervision. We need to apply that thinking to AI specifically and document what we're doing. Let's start with competence. This is Rule 1.1, and Opinion 512 is explicit. You cannot use a generative AI tool competently if you do not understand it. This sounds pretty obvious, but think about how most attorneys actually adopt these tools. They might sign up for ChatGPT, paste in a client matter, and see what the feedback is. That is a textbook violation Opinion 512 is warning against. Understanding the tool means several things. You need to know whether the tool retains your inputs, whether it trains on them, whether it shares them with third parties. You need to know its limitations, and the big one is hallucinations, which we'll come back to in the confidentiality section, because they intersect with candor and competence both. You also need to verify every output. 512 is clear. AI never replaces your professional judgment. It's a starting point, not an ending point. Competence isn't a one-time thing. These tools change constantly. The version of Copilot or Claude or ChatGPT that you onboarded last quarter is not the same tool today. Competence must be ongoing. DC Opinion 388 adds one more thing here. It explicitly warns against using AI for legal research without verification through traditional sources. That's a DC-specific right red line. Let's talk briefly about hallucinations. Hallucinations are really where this gets real, though. The DC bar borrowed a quote from an NPR piece and put it right in Opinion 388. AI is like talking to an eager to please intern who sometimes lies. The lie sounds confident. They sound articulate. They have proper citation format. They're plausible, and it's completely fabricated. What does a hallucination look like in practice? Citations to cases that don't exist. Misquoted holdings from cases that do not exist. Fabricated statutes. Misquoted holdings from cases that actually do exist. Wrong procedural rules. Made up legal standards that sound exactly right. The consequences are not theoretical. In the Mata vs. Avianca case, DC 388 used all of this as a springboard, as we mentioned, and it resulted in a $5,000 sanction, as well as other public sanctions, and there was professional embarrassment that the attorneys that received it now have to deal with. In Park vs. Kim, this was more recently in the Second Circuit, this resulted in a referral to the Attorney Grievance Committee, and there have been dozens of court sanctions since. The thing is that every single one of these was preventable with minimal effort to verify. The competence obligation under Opinion 512 essentially says it's malpractice and possibly an ethics violation to file something you got from AI without checking. Confidentiality is where violations happen every day. When you paste a client document, deposition transcript, or contractual draft into a public AI tool, ask yourself, where did that data just go? In most cases, it went from vendor servers somewhere in the cloud, could be retained, maybe used to train future versions of the model, and it may be processed by third-party processors that most of us have never even heard of. Opinion 512 is direct about this. Disclosing client information to what it calls a self-learning AI tool can itself constitute an impermissible disclosure under Rule 1.6, unless you have informed client consent or the tool meets specific confidentiality criteria. So what does that mean practically? Well, it means that you must do vendor due diligence before adopting a tool. You must know whether inputs are retained. You must know whether models train on the data, whether they know your enterprise contractual protections if there are any. The free version of ChatGPT or Claude, for example, those are not the same as the enterprise version with a business associate agreement and no training contractual terms. They are completely different risk profiles. If anyone in your firm is using a consumer-grade AI on client work, you already have a Rule 1.6 problem. So let's talk about some questions that you have to ask when you're doing due diligence. So here's a checklist. It's just 8 questions that need to be answered in writing before any AI tool touches client data at your firm. Does the tool retain inputs? Are they used for training? Who are the subprocessors and how secure are they? Where is the data stored geographically? What's the encryption posture in transit and at rest? Is there an enterprise agreement available with proper confidentiality terms? Should a breach occur, who notifies, who remediates, and who indemnifies? And can you delete the data on demand? If you can't answer all 8 of those for every AI tool your firm uses, that's your starting point. Get started on those. And I'd also like to flag something else that's practical here. Most of these questions sit at the intersection of legal contracts and IT security architecture. If you don't have internal IT, this is where an MSP becomes valuable. One like Wellforce helps our law firm clients run exactly this evaluation before any tool gets approval for use on client matters. Before we move on to client communication, I want to take a look at this a bit more in depth. We just walked through 8 questions you should be able to answer about any AI tool your firm uses. So let's actually do that for a real tool right now. I'm going to pull up, well, actually, I have it pulled up now, the webpage for Claude.ai. This is basically Anthropic's tool. Many of you are probably familiar with this. First thing that we're going to do, and this is pretty standard for any of the other tools that you probably would use on here. They're going to have a similar process that you can actually check this. For Claude, we actually click into the Security and Compliance tab. This is then going to open up the information that we're looking for. The first thing that we notice under here, under the overview, is it gives us the compliance related information that we would need that applies to any of the actual tools they offer, which are listed under the scope. Spread out to the right are each of the types of compliance that are covered under the agreement when you utilize these. 90% of the cases that we actually work with our clients, they're utilizing Claude Enterprise. As you can see, Claude Enterprise is essentially compliant to every other option that's available on there. The next thing that we want to look at are the subprocessors. You might be asking yourself, what is a subprocessor? Well, subprocessor is just a third-party company that the AI provider uses to help deliver the service and that may process customer data on the provider's behalf. What does this mean? Example, you're the customer. Anthropic or Claude is the primary processor. They can use another company, say a cloud infrastructure, billing, traffic routing, identity, which is what this is, that basically retains any of the credentials and passwords and keeps access safe. Those are all parts of this, and they use those companies to perform part of the work. Well, them doing that, the third party becomes a subprocessor because they may have access to the data required to provide the service. And this is all important to understand when you evaluate tools so you can actually see the types of access, security, and confidentiality that's provided. Now here's a few other things that I want to look at. The 2 questions out of the 8 that we looked at, the 2 questions that get absolutely first every time, and I want you to make sure that you understand how to look for them and what the language is. First one is the data retention. What is the data retention clause? So let's click under data processing to this. By default, Anthropic retains all customer data within the Claude for Work platform until the data is deleted by the customer. After deletion, we may retain for up to 30 days in our systems. Essentially, what this is telling us is when we delete our data, Claude has 30 days to get rid of the remaining part of the data on there. The reason that there's still that 30-day window is that they should be able to restore back to you anything that if you lost everything through just a mass deletion, they could restore it to you for 30 days without you having to recreate that. So it does sound, I mean, on the surface, it sounds like it's a bit nuts, but it actually is pretty good. And that's also pretty standard with any of the enterprise processes that you find through any of the other vendors. And the other piece is about model training. People don't always understand this one, but I think it's important to discuss. Will you be using Claude for Work conversations to train your generative models? No, by default, we will not use the chats or coding sessions when using commercial products. This is important to understand because this means any of the information that you're putting in cannot be used by them to train their models to make them better, to improve. Your specific information can't be used for that purpose on there. And I will tell you that from the actual commercial side back over to the consumer side, that's vastly different. Anything that basically goes into the consumer side, they're going to take that information and they're going to train the model in order to make things better on there. And so every time they roll out a new version of the model itself, it's all based on the information that all of those consumer products have been using for that whole time. So it's important to remember This is the type of diligence that needs to happen before any tool touches client data. It's going to take you probably 30 minutes to an hour to go through, but you need to document this stuff. The documentation is what protects the firm from under Rule 5.3 if a question ever arises. Rule 1.4 requires you to keep clients reasonably informed about the means by which you are pursuing their representation. The question Opinion 512 wrestles with is, when does AI use trigger Rule 1.4? The answer is nuanced. You don't have to disclose every time you spell check, and you don't have to disclose every time you use AI, but there are specific triggers. First, if the client asks, you have to answer honestly. That should be obvious. Second, if AI output is going to be a significant input into your professional judgment on the matter, that's a disclosure trigger. If you're using AI to draft a deposition outline or shape a litigation strategy, that's different from using it to summarize a long article you're reading for context. Third, if you need to put confidential information into a tool that doesn't have proper confidentiality protections, you need informed client consent before you do that. And fourth, your engagement letter, outside counsel guidelines, or court rules may already require disclosure. Many corporate clients are now adding AI disclosure requirements to their OCGs. I've included sample engagement letter language here that you can adapt. The key elements are acknowledgement that AI may be used, statement of attorney supervision, statement of confidentiality standards, and a carve-out requiring client consent if you need to put privileged information into a tool that doesn't meet your standards. If you're a managing partner, a practice group leader, or you supervise associates and staff, this slide's for you. Rules 5.1 and 5.3 don't change because of AI, but Opinion 512 makes explicit how they apply. Under Rule 5.1, your duty as a supervising lawyer extends to making sure the lawyers you supervise are using AI ethically. That means firm policies, training, and monitoring. And when something goes wrong, that means remedial action. Under Rule 5.3, AI tools are essentially treated as non-lawyer assistants, like the vendors who handle your e-discovery or your court reporters. You have a supervisory obligation over that vendor relationship. You need to do real diligence with the vendor. You need to maintain ongoing oversight, not just a check-the-box review at onboarding. And critically, document it. If something goes wrong and a disciplinary committee looks at your firm, the question they will ask is, what did the firm do to manage this risk? Your documentation is your defense. So what does a firm AI policy look like? There are 6 core elements. 1, an approved tools list. Be specific. Not, we allow AI, but we permit these specific tools with these specific configurations for these specific categories of work. 2, prohibitive uses. These are the categories of information that should never go into a consumer-grade AI tool. Client privileged communications, trade secrets, health information protected by HIPAA if you do healthcare work. Be explicit about the no-fly zones. 3, verification standards. Every AI output gets reviewed before it touches a client matter. Define what the review looks like for research, for drafting, for document review. 4, client disclosure protocol. When do you disclose, what language do you use, and how do you document consents? 5, training. Mandatory for all attorneys and staff. Provide an annual refresher and track completion. 6, incident response. When something goes wrong, and eventually something will, you need a plan. Who gets notified? How do you remediate? What do you tell to the client? This isn't a 100-page document. For a small or mid-sized firm, it can be 5 to 10 pages with all the relevant information. The point is that it exists, it's followed, and it's documented. Walk through the 6 elements of a firm AI policy in the abstract. Let me show you what it actually looks like when a firm puts one together. What I'm about to share is a policy from a 12-attorney firm here in the district. It's a real document with real language, we've just changed the names. This is one example, it's not a template, and your firm's version should reflect your practice mix and risk profile, but it'll give you a concrete sense of the level of detail that we're talking about. Okay, so here we go. We've opened this up for this firm, Hartwell Bryce, LLP. What we want to do is start by scrolling down to the Approved Tools section. Notice that we have the following tools listed on here: Microsoft 365 Copilot, Cloud for Work, Lexis Plus AI, and Westlaw Precision with CoCounsel. What we've got in here is we have the tools listed out explicitly, the configurations, and the approved uses on there. I think this stuff is pretty important for you to be able to get the staff to understand what it is that you're looking for. Likewise, we have the prohibited tools and configurations, and this one here is vitally important. Its use of any consumer or free tier generative AI tool, including but not limited to free ChatGPT, free Claude.ai, Gemini, or any personal account tool in connection with any client matter. That's important on there because that is an automatic compliance violation on there, and you want to actually avoid that. The next thing that we're going to look to do is we're going to move down to the prohibited categories of information. And the firm has them listed here for the types of things that they are looking to actually prohibit. So there's anything that has information on a court-ordered seal or protective order, information protected by the attorney-client privilege of a client who has not consented to AI use, etc. Next step is we want to actually go down to the engagement letter language. And this is important because this is actually going to allow us to show out how you have this written out. Now, obviously, I'm not a lawyer. You are, so you're going to have a better idea of this. But I'm going to read some of this off to you. In providing services under this engagement, the firm may use generative artificial intelligence tools to assist with tasks such as legal research, document review, drafting, and analysis. Any such use is subject to attorney's supervision and review. And if we actually skip down here, if you prefer that we not use generative AI tools in connection with this engagement, please notify the responsible attorney in writing and we will accommodate your preference. Now, this is important because it refers over to the client opt-out. No client has to actually have or has to give you clearance to be able to use this. They can opt out of this, and you're not going to be allowed to use that based on this. So if they want to opt out under section 3.1, the responsible attorney shall document the opt-out in writing in the matter file, notify all attorneys and staff working on the matter, and confirm the opt-out at the start of any successor matter for the same client. And there's actually one other thing before I jumped over here. There's one other thing that I wanted to show you in here. I jumped ahead, I apologize. We actually want to go through the verification standards, and this will actually show what we've got here in terms of a workflow. So in the workflow, it'll say all output from any generative AI tool that's used in connection with client work, internal legal analysis, or any external communication shall be verified by an attorney or other qualified personnel before being used or transmitted. We actually referenced that previously. Just because you're using it doesn't mean the answer that you're receiving from it is the actual answer. You have to verify that this information is correct. It's helping you to streamline the process of research and coming up with frameworks on things, but you cannot assume that you're getting the correct answer from this. All of this stuff needs to be checked and verified in order to be compliant. Fees. This is the section that consistently surprises people. There's 3 rules. Each one is more direct than you might expect. 1, you cannot bill clients for the time you spend learning how to use an AI tool. Learning a new tool is firm overhead, not client work. The one exception is if a specific client has requested you use a specific AI tool for their matter. Then the learning is directly attributable to that engagement. 2, you cannot pass through AI tool subscription costs as a line item expense. Your Copilot subscription is overhead. Your firm's enterprise ChatGPT contract is overhead. You can only pass through costs that are genuinely incurred for and attributable to a specific matter, like a one-off AI tool licensed for a particular case. And 3, you must bill for the actual time spent, not the hypothetical time saved. If a research task that used to take you 10 hours now takes 2 while using AI, you get to bill 2 hours. You don't get to bill 10 and then pocket the difference, even if your engagement is hourly at an agreed rates. DC Opinion 388 takes the same position. The efficiency dividend from AI belongs to the client, not the firm. Beyond the 5 core obligations, Opinion 512 flags 2 more rules that come into play when AI generated content makes it into a court filing. Rule 3.3 Candor toward the tribunal. You cannot knowingly make false statements of fact or law to a court. When you cite a fictional case to a court, you have violated Rule 3.3, and I didn't know it was fake is not a defense when basic verification would have prevented it. Rule 3.1 Meritorious claims and contentions. Arguments built on hallucinated case law don't have a basis in law and fact. That's a Rule 3.1 problem on top of the Rule 3.3 problem. And here's the operational piece for DC practitioners specifically. A growing number of federal judges, including some in the DC Circuit, have issued standing orders requiring certifications about AI use in filings. Some require certification that no AI was used, while some require certification that any AI generated content was verified by a human aid against primary sources, and this can vary judge to judge. It's very important that you check the standing orders for every judge before you're filing. Build it into your checklist. If you're using AI in any way in your drafting, you need to know what each judge requires. Now I'd like to tell you what I've seen when I engage with law firms. These are the 6 most common governance gaps. Most firms have at least 3 of them. There's a lot of them that have 6. No written AI policy. Every attorney sort of makes it up as they go. Some are careful, some are not. Variance becomes institutional risk. Consumer grade tools used on client matters. Things like free ChatGPT accounts or personal cloud accounts. A free Gemini. None of these have the enterprise contractual protections that you need for client work. No vendor due diligence on record. The firm uses tools, but when you ask why those tools and not others, or what diligence was done, there's nothing. That's a Rule 5.3 problem if something goes wrong. Inconsistent disclosure. Some partners tell clients, others don't. Engagement letters are silent. There's no firm position. No training program. Attorneys learn from AI using LinkedIn and YouTube. Some of it's good, but a lot of it's not. Outdated billing practices. There's time entries reflecting pre-AI workflows, so the same task that took 6 hours now takes 90 minutes, but the bill still says 6 hours. That's exposure that compounds every month. If you're seeing your firm in any one of these, that's exactly why you're here today. So here's what actual good implementation looks like in practice. It's just a 90-day roadmap that moves you from where most firms are to operational AI governance. In your first 30 days, you perform a full assessment. Inventory every AI tool in use at the firm, including the consumer grade ones that attorneys are using on their personal accounts that you don't even know about. That's a shadow IT problem. Map your vendor relationships. Survey attorneys on what they're using. Identify high-risk practices. Step 2, days 31 through 60, you begin designing your compliance and governance framework. You draft the policy. Define approved tools lists. Develop the engagement letter language. Build out the verification standards for different types of work and design your training. And in stage 3, which is days 61 through 90, you deploy. You roll out the policy. You deliver the training and track completion. Update your engagement letters going forward. Establish a recurring review cadence to reflect as the tools change, your policy will evolve with them. And document absolutely everything. Your documentation is your best defense. So here's a practical word about how all this is going to get done. And really, any firm of any size that doesn't have internal IT, they're not going to be building this all out on their own. And honestly, even larger firms with an IT team internally probably don't have the bandwidth or the specialized AI governance expertise to do this well. This is where a managed service provider like Wellforce IT fits naturally. A quality MSP should have expertise in the following areas. For vendor due diligence, when a new tool is on the table, we run the technical evaluation. Look at the data flow, the security posture, the subprocessors, the contractual terms. We give you a written assessment you can put in your file. Data security and configuration. Most enterprise AI tools have significant configuration controls. We make sure that your Microsoft Copilot tenant is configured properly, that DLP rules are catching what they should, and that access controls match your firm's structure. Compliance monitoring. This is continuous oversight. AI use changes over time. We watch the patterns, flag any anomalies, and maintain the audit trail. Training and documentation. We provide the attorney training, policy templates, and documentation that becomes your defense if someone ever asks how firms handle this. This is what we do for our clients. It's a partnership model. You stay in charge of the real legal judgment. We handle the technical infrastructure and documentation that supports it. There's 6 things that I would like you to take with you from today. Number 1, Opinion 512 doesn't invent new ethical rules. It applies the rules you already know: competence, confidentiality, communication, supervision, and fees, but with a new tool. 2, in the district, Opinion 388 is your local authority. The ABA framework is informative and persuasive, but 388 is what binds you. Read it, reference it, apply it consistently. 3, confidentiality is the area where most firms have quiet, ongoing violations occurring right now. Consumer grade tools, no vendor diligence, no documented standards. If you only fix one thing this quarter, work on this. Number 4, hallucinations are entirely preventable with basic verification. The cases where lawyers got sanctioned are cases where a junior associate or a paralegal with 30 minutes might have caught the problem. Build this verification into your workflows and you eliminate this entire risk category. 5, your billing practices must evolve. The efficiency dividend from AI belongs to the client, not the firm. Build that into how you bill, how you structure engagements, and how you talk to clients about value. And 6, documentation is your defense. If you ever get a question from a disciplinary committee or a client's general counsel, the question will be, what did the firm do to manage the risk? Your written answer, policy, training records, diligence files, those are what protect you. And we've just got a quick reference list here of the materials underlying everything that we covered today. Um, this is just things so that you know that we're not just making things up on there. And just as closing, we just want to look at where we would actually go from here. And there's 3 paths depending on where your firm is and what you need. And first path, you take the quick reference card that we'll be sending out and run a self-assessment. Walk through it with maybe your partners or general counsel and identify where you are on the obligations. That alone is enormously valuable to your firm. Path 2, if you'd like a second set of eyes, we offer a 60-minute working session, complimentary to webinar attendees, where we help you identify the top 3 governance gaps for your specific firm and prioritize them. There's no sales pressure, just a working conversation. Path 3, if you want full implementation, policy development, vendor diligence, training, ongoing monitoring, we offer scoped engagements based on firm size and risk profile. We work with everyone up through mid-sized firms across the DC market. You can email us on the next slide or grab time directly on my calendar. I'm happy to do any of it. I'd like to thank everyone for joining us today. And there's just a final few pieces. You receive a follow-up email tomorrow with the slide deck, reference list, and a quick reference card that consolidates everything we covered today into a 1-page operational checklist. If you'd like to schedule the complimentary 60-minute consultation, contact information is on this slide and in the follow-up email. We work with law firms across DC and the Research Triangle markets. This is the 2nd session in our AI Ethics and Governance webinar series. The next session is going to focus on practical AI workflows for legal teams, specifically how to integrate AI into research, drafting, and document review while maintaining everything we talked about today. Watch your inbox for the invitation. Thanks again for your time, and have a great day.